time, at the same time, we will be hosting another session on driver's license suspension. So you are all welcome to attend. You just need to go to our website, go to the events page on our website, and you can register from there. And so I will turn it over to Cullen, who's going to share his screen and go through a presentation with you all. Thank you for joining us.
All right. Well, good afternoon. I am Cullen Sweeney. I'm the Chief Public Defender in Cuyahoga County, and our office here has been doing record sealing for some time, but we really focus on sealing felony records. So we have worked with legal aid quite a bit. And we do a lot of referrals to legal aid. But if somebody has a record that needs to be sealed in a common pleas court, our office will handle it and will represent the person. We also do some record sealing in juvenile court, and we're going to talk a little bit about juvenile record sealing, although the focus of this is going to be on adult record sealing. And our office also has multiple divisions. We obviously represent individuals charged with crimes. That's sort of our primary mission, both in felonies, misdemeanors, and in juvenile delinquency. We also represent parents where there's an allegation of abuse or neglect. And then we do a lot of post-conviction stuff, appellate stuff, and record sealing in common pleas court. So I wanted to just talk about kind of how the law has changed recently. One of the biggest changes, and this was with Senate Bill 288 that just went into effect in the beginning of April. And one of the biggest changes is that it has created for the first time a true expungement provision in the law. It used to be that, and by expungement, I have a definition here, and this is from the statute. Expungement means that a rentley irretrievable. And we have for many years talked about expungement in or an easy word to talk about where this law was enacted. What you could do is seal your record, which means that
Cullen,
it's not destroyed, but it is not shared with most entities. Oh, shoot.
I think we're having some connection issues. I don't know if you can hear me, Cullen.
I can. Can you hear me? Can you hear me now?
Yeah. Now.
Sorry.
Oh, it's okay. That's what happens on Zoom trainings.
Yeah. I usually the connection is pretty good, but if it goes out, Lauren, you can just pick it up. Just let me know.
Of course. Yep.
So that's one of the big changes with the new law, is that now records can be expunged, and we'll talk about the different procedures for sealing records versus expunging records in just a minute. But just a real quick historical context. So the law in Ohio used to be fairly restrictive about sealing records. And before 2012, you could only seal a single conviction. And as you can see, there have been a number of changes over time. In 2021, there was a big change that allowed for basically an unlimited number of felonies of the 4th degree, 5th degree, and misdemeanors to be able to be sealed for somebody that's defined as an eligible offender. And that eligible offender definition is what kept the number of people from being able to qualify to seal their record. With the new law, it has removed any consideration of whether an individual qualifies as an eligible offender, and that has very much expanded the number of people that can seal their records. So as I said, 288 expands who can seal their records, which records can be sealed, and it added in the possibility of actually expunging the record versus just sealing them. So when we're looking at whether or not you can seal a record, there's basically three important questions. One is whether or not the conviction that you're looking at is eligible, is one that can be sealed or expunged. Whether the sentence was totally satisfied, and by that I mean the person has finished probation, has paid any fines or restitution, has finished prison if they went to prison, and there's a waiting period, which we'll talk about, that the person has to have gotten past to seal it, and whether or not there's any other unrelated criminal proceedings, because that impacts your ability to seal. And just graphically here, I've crossed out the eligible offender piece, which was a big part of the analysis previously. And when you talk about what convictions that cannot be sealed, there's a couple of big categories of offenses. One is anything that's a felony offense of violence. And those are probably things that you mostly would think of. Murder, rape, basically, aggravated burglary, aggravated robbery, that kind of thing. There's a few that wouldn't necessarily totally jump out to people as a felony offense of violence, and they're listed here. Escape, extortion, some people may think of it that way. Other ones that we get a lot of requests about that cannot be sealed are domestic violence offenses, felonies or misdemeanors cannot be sealed, or violations of protection orders. There was a change, and we'll talk about it a little bit later too, or I'll get to it in a minute, but it used to be that no sexually oriented offenses could be sealed at all. Now there's a minor change to that, which is sexually oriented offenses that are not first or second degree felonies. Once registration is completed and a waiting period has passed, those can be sealed. Any case where the victim is under 13, except for criminal non-support, so basically the failure to pay child support, those can be sealed, but any other case where the victim is under 13 can't be sealed. And any traffic offense. And so where we see this the most is with OVIs. A lot of people are looking to seal an OVI. That can't be sealed, but neither can speeding tickets and things of that nature. As far as when you can seal it, the first part of that is you have to fully have discharged the sentence. And as I mentioned before, it basically means kind of what it sounds like. You have to have done everything that was required of you as a part of the sentence. And that could include prison or jail, probation. If you go to prison and you're on post-release control, you still have to finish that time period out. And also have to pay fines and restitutions. One thing that often or sometimes will come up, someone may finish probation, but they haven't paid the restitution back. And there's a case here from the Supreme Court. You have to have paid the restitution or have it satisfied in some way, either waived or forgiven or discharged in some way in order to be eligible. The one thing that does not count as a financial sanction, because it's not part of the criminal sentence, is court costs. So technically, to be eligible to seal your record, you don't have to have paid the court costs. Though I will note that most courts will want you to have paid the court costs. So whether they're paid or you can make the case that they should be waived, usually before a court seals a record, they want to address the court costs in some way. So in addition to the conviction being eligible to be sealed and having served the entire sentence, there's also a waiting period imposed before you can seal a record. So as you can see in the chart here, For minor misdemeanors, it's 6 months. And then misdemeanors, F4s and F5s, it goes up to 1 year after you finish the sentence. F3s is 3 years. And then there's 2 kind of very specific circumstances where there's a longer waiting period. This is basically the 7-year one relates to a public official soliciting or accepting bribes. And then the sexually oriented offenses one that I talked about. So there's a waiting period for record sealing. And so once you pass that time period and you've satisfied your sentence, an individual can file to seal the record. Now, as I talked about, there's a distinction between record sealing, which is basically just keeping it from public view, preventing most entities, especially private entities, from being able to seal the record. There's one time period for that. And then there's a longer time period in most cases to expunge the record, which is to make it permanently inaccessible to basically everyone. There is one exception in the statute, and that relates to law enforcement being able to see it and to make hiring decisions, basically. But as you can see, for misdemeanors, the waiting period is the same for record sealing and for expungement. So if someone's trying to seal a misdemeanor, they might as well seek to expunge it at the same time because it's the same waiting period. It's quite different for felonies because there's an additional 10 years you have to wait to expunge your felony record in general. So while you can seal a low-level F4 or F5 after 1 year, you can't actually expunge it for 11 years. And then again, with F3s, you have to wait 13 years. So there's a longer time period to do that. So there was, I see that there's was a question about sealing and expunging at the same time. And yes, as I was saying, it makes sense if you're eligible, seal and expunge just do it at the same time. But in some cases, with felonies, you're most likely not going to want to have to wait another 10 years, and you might as well seal it first to at least get some benefit of having the record removed from public view. The other thing that has to be taken into consideration is you can't seal a conviction if you have other pending criminal proceedings, even unrelated cases. So it used to be that, I didn't get into the definition of what it meant to be an eligible offender, but it used to be that you would look at a person's entire criminal record to decide whether they were eligible, because certain convictions would disqualify you from sealing anything. But you don't need to do that anymore, because now you're just looking at the specific case you're trying to seal. The only exception to that is if the individual has another pending criminal case. So maybe you've got 2 cases from 2010 that could be sealed, but you have a pending misdemeanor theft case right now. So if that's the case, then you would not be eligible to seal anything, even the older cases that have passed the waiting period, until you've resolved the more recent case. Once you resolve that case, you can seal on the older cases, even though you haven't passed the waiting period necessarily to seal on the most recent one. Something that also comes up fairly often is somebody might not have a pending case, but they are on probation in a case. There's actually some mixed case law on what is the implication of being on probation. I usually tell people that it is better to be off probation. You're a better candidate for, even if you could argue you're technically eligible to seal another case, you're generally a better candidate to get your record sealed once you're off probation. And sometimes the other thing a number of our clients run into is they may be eligible to seal and pass the waiting period, and they don't have any criminal cases, but they have a number of warrants from various municipalities, basically in traffic cases, where they have unpaid court costs. My view of the law is technically that does not make you ineligible, but most courts, again, don't want you to have even a traffic warrant. So usually, to the extent possible, we encourage our clients to resolve all outstanding matters. So just to give a quick sort of time frame and process for record sealing, it depends on the court in terms of how quickly it moves. But just speaking first about common pleas court, the first step is to file the motion, and you can do this on a client can do this on their own with pro se forms. In common pleas court, we'll represent them and file it. The next step is they do a background check at the court to look at their entire criminal record. The state of Ohio or prosecutor has a chance to respond, and then there may be a hearing. If there is no opposition from the prosecutor's office, and honestly, my experience, at least in common pleas court with the county prosecutor, is for the most part, if somebody is eligible to get their records sealed, they don't generally oppose it. They tend to oppose in very specific cases where somebody's eligible, or they'll oppose it if there's an issue like the person has unpaid restitution. But if there is no opposition, then most courts will grant it without a hearing. In some cases, some judges, if there is opposition, or some judges in any case, might hold a hearing and decide that way. The entire process from beginning to end usually takes, on the really shortest end, at least in common pleas court, about 2 months, and may take 4 or 5 months, depending on whether there's a response, whether there's outstanding issues, whether a hearing has to be scheduled. So it's the kind of thing that I know a lot of our clients are anxious to get these records sealed, but it generally does not happen overnight. My sense is some of the misdemeanor municipal courts are a little bit quicker in that process, but I don't have a lot of personal experience with that. So we've talked a lot about expunging convictions, and for most people, that's kind of what they're particularly concerned about. But we also have a lot of our clients have cases where they were charged with offenses, but they were dismissed, they were found not guilty, or it was no billed, that is, the grand jury didn't return an indictment. And those are still showing up on their record. And really, for a lot of people, if let's say you were charged with a serious offense, like we've had clients charged with murder where the charges were dismissed. Well, when an employer gets a background check, all it will say is, murder. It doesn't say, a lot of times doesn't really explain what happened to the case. And even if it does, having that on your record is going to be obviously a huge problem. So you can seal these cases as well. And we do it, and and a lot of our clients.
I'm going to jump in here.
That
Colin, it went out again. I think you look like you're back now, but maybe not. Okay. Well, just in case anyone wasn't. Can
you hear me?
Yes, but you're not moving on your screen. I think what Cullen was explaining is that with some people are not necessarily as concerned about not guilty cases, but that we do typically recommend that they have them sealed. for a variety of reasons. A lot of times, people that just search dockets to figure out if someone has a criminal record may have not a great understanding of what they're seeing, even if the person wasn't convicted. So at Legal Aid and the Public Defender's Office, we all recommend that if there's a case out there, and especially if they're already going through the process of sealing convictions, that doing this in addition is helpful for people. There is that important point down here, though, no expungement option. So you are still sealing the not guilty cases. You are not expunging them. They did not add expungement to this statute. So this is still just a record sealing for these cases. And that's actually come up several times just since the law changed in April for us.
So Lauren, can you hear me again? Okay. Apparently the county needs to pay its internet bill or something, but anyway, so thanks for jumping in. There's also dismissed cases, which is just a variation on the not guilty. The one thing about not guilty and dismissed cases is there's also no waiting period. So immediately after the case is dismissed, you can file to seal it. But as Lauren pointed out, you cannot expunge it for some reason that honestly doesn't make much sense to me, but that's what the General Assembly did. And then no bills, which is, we don't see a ton of these, but it's basically when the case has been presented to a grand jury and the grand jury decides not to bring charges. The only difference with these is you actually have to wait 2 years after the no bill before you can file to seal it. One other change in the new law is that you can seal pardoned convictions. And so one of the reasons that's important is you may have a case where the individual is not normally eligible to seal the conviction. Let's say it's an involuntary manslaughter case where the individual was a battered spouse. And so there were good reasons why now the governor might say, I'm going to issue a pardon of that offense. And so the pardon does relieve legal impediments that you would experience as a result of the conviction. But the act of pardoning someone does not result in it actually being sealed. And under the old law, you could not seal an ineligible offense, even if it's been pardoned. That was changed by the new law. So if you have someone who has an offense, maybe 20, 30 years ago or whatever, that can't be sealed, a pardon is an option. And if it is pardoned, then it can also ultimately be sealed. I'm not going to spend much time on the juvenile records, but I will just note that I think a lot of people assume that these records can't be seen because they're in juvenile. And in some cases, they do still show up on people's background. So there is some automatic aspect to the record sealing and expungement provision in juvenile records, but it is something that if there is a record that is showing up on someone's background check, it's something that we will assist people with filing early. So the only juvenile records that can't be sealed are aggravated murder, murder, and rape. So, and the process is a lot simpler. And there was always an expungement provision for juvenile records. And so all sealed juvenile records are automatically expunged after the individual turns 23 or 5 years after the record has been sealed. So it may be a good idea to get, especially if it's a serious case, get the record sealed because then it will automatically be expunged after a certain point in time. You can also apply to expunge them earlier for good cause. There are, I think I don't know, Lauren, were you going to talk about the CQEs, I think?
Sure, I can talk about them.
So that's pretty much it on my portion of talking about the expungements, but there are some people who can't get their record expunged. And so there is this one alternative that Lauren will talk about.
Yeah. And one other thing I wanted to highlight with record sealing is that if you're working with people who are interested in record sealing, one of the common questions that comes up is what is the cost to do that? And that was interpreted in many different ways prior to April of this year. The new law attempts to make that clearer, so that the cost shall not be more than $50 to file to have a record sealed. And when you're working with both legal aid or the public defender's office, if you are eligible to qualify for a fee waiver, we will help with that process to get those fee waivers filed so that the cost is nothing for those that are eligible. But for those that aren't eligible for fee waivers, the cost should now be only $50. Many municipal courts were charging in the $150 to $200 range to file for record sealing. So that is a big cost savings that we believe was always supposed to be, was part of the statute, but was just interpreted differently depending on the court that you were talking to. So that's another big piece of this. And I guess one other thing I want to highlight is, for those of you working with people in the community who have come to legal aid, come to the public defender's office, talked to someone in the past and been told they were not eligible to seal their record, it is certainly worth talking to them again about exploring that option. As Cullen mentioned, many people were told they were not eligible to seal their record because they were an ineligible offender, or they didn't meet the definition of eligible offender, which was really, for the most part, a counting exercise based on total number of convictions. There were some, depending on the types of convictions, that did have a little bit of an impact, but it was basically how many convictions do you have? And if you went over that certain number, there was no opportunity to, expunge or seal back then anything. So as you're working with people moving forward, who've had that assessment done in the past, if they're interested, please have them reach back out. We'll talk a little bit about how they do that at the end, but just keeping that in mind, that this greatly expands the number of people who would be eligible to seal some, if not all, of their records. So send them back our way, even if we've told them, if we've told them since April of this year that they're not eligible, that's likely still the case based on the law. But for people that came to us prior to this year, it is worth them re-exploring their options when it comes to record sealing. So I'm going to talk about a CQE. So CQEs are available for individuals who are not eligible for expungement or record sealing. They are technically available to individuals who seal and expunge their records as well. There is no, you don't have to choose between those options. And we do talk to people sometimes who have a record sealing, but are still interested in a CQE for a variety of reasons. And so what a CQE does is it addresses barriers to employment due to the Ohio convictions under Ohio law. So when you're looking for a CQE, what you're thinking about is what are the collateral consequences of these criminal convictions that I have? What am I prevented from doing, specifically with regard to employment, although some people have used them in an expanded way to think about housing as well. But what am I prevented from doing due to these convictions? So it removes mandatory barriers to employment, which means that, employers must make an individualized decision about someone who has a CQE. It can't just be, that we just can't hire this person because of the conviction. And it creates a rebuttable presumption of rehabilitation when you apply for a professional licensing. This is an instance where we sometimes help people with CQEs, even if even after they've had their records sealed. So a good example of this was when previous to April, people that had certain criminal convictions were eligible to have them sealed, but were interested in applying for certain state licensing, especially people we were working with were interested in healthcare licensing, such as becoming a nurse. We would sometimes recommend a CQE based on that conviction, mostly because when you were applying for that licensing, there was often a requirement that you disclosed all convictions, even those that were sealed. And so the CQE was an opportunity to basically have additional support that you were rehabilitated and employable. And it establishes immunity for employers from non-negligent hiring lawsuits. So this is what the employers are receiving as a benefit when they hire someone with a CQE. They can't be accused or sued for negligent hiring of these individuals if something did happen once they were employed. So that's the protection that the CQE, which is granted by a court, is offered to employers. But there are limits to a CQE. So you can't have relief for sex offender registration requirements, driver's license suspensions or revocations, restrictions on law enforcement or prosecutor employment, healthcare licenses for certain convictions. So, what I was talking about earlier, but for certain convictions, it was not that rebuttable presumption. And then eligibility for working in a pain clinic. So even with CQEs, these things are not able to be rebutted. And then for a CQE process, so the CQE process is a bit different than the record sealing and expungement process. Record sealing and expungement is related back to the original case. So if you're working with someone or you have multiple cases, a few in Cleveland Municipal Court, a few in Cuyahoga County Common Pleas, maybe some out in a different municipal court, you're filing to have those records sealed on those original cases. You're going back to the court where the conviction or the case occurred, and you're asking for that individual court to seal the record. The CQE process is more streamlined in that it is one application that you're filing in the Common Pleas court in which you live. So you first, to go through this process, you apply online, and then you get approval to basically file your CQE application. And so the approval comes from DRC. And then you take that and you go and file in your municipal court. There will be a court hearing on that. In that filing, you're going to list what are the collateral consequences that you're experiencing, that you've been rehabilitated, that you meet the other requirements of a CQE. There are still some requirements that exist. It is much less in terms of requirements than record sealing, but there are still some requirements. And then the court will either grant or deny the CQE. Legal aid helps with these. So if people are interested in a CQE, they're welcome to come to legal aid to apply for help. We typically help with the applying online and getting the approval. People usually file in court on their own, but if there are issues that come up after they file, legal aid will get involved. All right, so, now I'm sure you're all wondering, okay, this is great information. We're excited to hear that this law has continued to expand in terms of who is eligible and which types of cases are eligible. We're working with a lot of people that are very interested in this. How do we get people to your organizations and to other organizations that can help? So we have a lot of information on that. So the first place that you can refer people is the Cuyahoga County Office of the Public Defender. You would want to send people there who have the cases handled listed there, but really for expungement purposes, it's for people that had cases that were heard in Cuyahoga County Common Pleas Court. So regardless of the outcome of those cases, if they were heard in the Common Pleas Court in Cuyahoga County, you can send them to the public defender. If you are working with people and you're thinking, they're mentioning they have a lot of cases, I'm not really sure how to determine which case was heard where, which is very typical, very common. First of all, in Cuyahoga County, our Justice Center houses both the Cleveland Municipal Court and Common Pleas, and sometimes it can be really confusing for individuals, especially if the cases are old, to know where exactly they had to attend court and what happened. They're often in Cleveland Muni and then move up to Common Pleas. So it can be confusing, and we understand that. So we tried to make it as easy as possible for clients and for individuals working with clients. And so if you go to the Cuyahoga County Office of Reentry site, there's actually an application process on their website, and you can help someone fill that out. And that information then goes to the public defender, who helps figure out who is the best organization to serve this individual. So looks at the record, figures out what's going on, and makes that decision and the appropriate referrals. The partners that work together in that Office of Reentry portal to make sure that we're all serving individuals that need help are both the Office of Reentry, the Public Defender's Office in Cuyahoga County, the Legal Aid Society of Cleveland, but also we work closely with the law schools. So Case Western Reserve University has a second chance reentry clinic, which does a lot of the work that we talked about today. They do some additional work with child support modification and child custody and visitation, typically in conjunction with individuals that are dealing with trying to get their records sealed or expunged or looking for help with CQE. You can contact them directly, or you can, if a client is referred to that Office of Reentry website, they will be referred to the Second Chance Clinic if it's the appropriate place for help. And then there is also the Pardon, Clemency, and Reentry Clinic at Cleveland State University College of Law. And that, again, they do a little bit more work with pardons. As Cullen mentioned earlier, there are pardons available. They do some work with the Pardon project that is a statewide project. They also do record sealing and expungement work, and then some post-conviction relief. We will share these slides. That's their information directly. But again, they also get referrals through that Office of Reentry, centralized portal for everyone. And then finally, the Legal Aid Society. So we assist with record sealing in expungement cases in Ashtabula, Cuyahoga, Geauga, Lake, and Lorain counties. So in Cuyahoga County, we are helping seal records in the municipal courts. So anything but Cuyahoga County Common Pleas. If we have a client who has a Common Pleas case, we refer directly to the public defender. So we work closely together to make sure that clients are going where they need to go. And then we also cover Ashtabula, Geauga, Lake, and Lorain, both the Common Pleas courts and the municipal courts. Sealing in at both levels in those counties. And as I mentioned, we help individuals obtain the certificates of qualification for employment, the CQEs. If you have people that are interested in that, then you are welcome to refer them to our website. You can apply for legal aid's help on our website, or that is our phone number for our intake hours. But I think we all want to stress that we work well in partnership on these issues, and we're very good at referring to the organization that is best suited to help individuals. If you're helping people get connected to any one of us, we'll make sure that they get where they need to go. And the other piece of this is that we also spend time talking to people about why they might not yet be eligible. So a lot of people that come to us who are looking to seal their records for a variety of reasons might not be eligible. Perhaps it's just something like they haven't waited the required waiting time, or they need to complete paying their fines and then wait the waiting time. And so, or they have open pending cases. And so, while of course we help with the record sealing and the expungement piece, all of us are also talking with people about their eligibility under this law and why they may or may, why they may not be eligible. And if for someone who just is not going to be eligible under the law, again, giving recommendations of other options, whether it's the CQE or pardons, or just talking them through, what applying for a job will be like if they're not able to get any of those things put in place at the moment. So we spend a lot of time doing that, hopefully less time doing that now because more individuals will be eligible. But certainly that's a big piece of the work that we're doing is talking to people about why they might not yet be eligible and what they can do to become eligible. Does anyone have any questions for us? Things that you're wondering about with the new law, or just process, how to get people to where they need to go? Anything we can do to help you understand this law, which I think Colin and I can, it is confusing for people that work in it. So I have to imagine that, for if this is your first time really digging into this, it's a lot of information to take in.
Hi, Lauren. I actually do have a question. If I have a client that has, let's say they have a felony in Cuyahoga, a misdemeanor in Akron, and then an out-of-state offense somewhere, what would that look like? Because we're in county, a whole different non-service area, and then out-of-state.
Yeah, so in terms of, it used to matter a lot because convictions everywhere counted towards the determination if someone was an eligible offender. Record sealing laws are state laws, so different states have very different laws around what is a record sealing, what is an expungement, what's eligible, who's eligible. So in that situation, we would look at the cases that are in Ohio to make decisions about whether those are eligible to be sealed, and then, hopefully be able to help them file. As I said, you would file on each of those cases. So if there's two cases and they're eligible to seal both of them, you'd file a motion in one case and a motion in another case, when they are separate filings. Hopefully that's a good answer for you.
The ones I'm concerned about, I'm sorry. Oh, go ahead. I'm sorry.
Well, one thing I was going to say is that there's a number of public defenders in different counties that do some record sealing, and I imagine the same is true for legal aid organizations. So Summit County, for instance, has a good record sealing clinic that they do monthly. So I think if you refer the person to either the public defender's office or legal aid, and there is an ability to refer them to another office in Summit County, for instance, we will definitely do that. So that's come up quite a bit for our clients. It's a little bit more difficult for out-of-state convictions because you need to go to that state to get the records sealed. And so it won't impact their record sealing here necessarily, but if they want to seal that record, then they'll have to go to the other jurisdiction.
Okay, that was the other part of my question, because it's come up twice now, where my client had out-of-state and in-state convictions. Thank you.
So there's a question in the chat about the impact of the new law, if any, on those trying to find housing. So I think you bring up an excellent point that criminal convictions not only have implications in job searches, but also in housing searches. So if the record is sealed or expunged, and someone is running a background check on someone, it should not be appearing, so that they should not be able to see those records. I will say that I had mentioned earlier, the recommendation to seal non-convictions. So those cases that were dismissed, or the person was found not guilty, or they were no billed, that is one of the major reasons that we recommend that, because we find a lot of times our clients will say, well, my landlord looked me up on the docket and saw, you know, this case from however many years ago, you know, so that has a larger impact, and even if the person wasn't convicted of it. So, you know, I don't know. The new law has been in place for a very short time. So we have handled a handful of cases under this new law. And I honestly do not have, Colin, I will ask you, I do not have a lot of information on process. We have not had anyone who applied for an expungement have it denied, but I don't know that we've had anyone had it granted either at this point, because we processed the April ones and people filed like at the end of April. So I don't think anyone's had a decision made yet. And even after that decision's made, it takes some time for the court to send the information where it needs to go to actually get that record sealed and expunged. So I don't have a lot of info on the new law and its impact yet.
So, and one thing just to emphasize a point that Lauren was just talking about is that we often tell clients, like, if you get your record sealed today and you're looking for a job next week or applying for housing, chances are it's still going to show up on your background. And sometimes it will be even much longer than that. And so part of the problem is that private background check companies that run background checks don't necessarily consistently update their background check. So it is possible, especially for the first few months after your record's been sealed, that it will still show up on a background check. So, you know, it's not a perfect system in that regard. If something does show up on your background that should have been removed, you do have a right to get it removed. So you can write a letter to the background check company to get it removed. Now, of course, that's too late once the landlord or employer has seen it, but it's a way of at least correcting it so it doesn't continue. Usually after about 6 months, I would say you're pretty safe, but sometimes we've seen things still show up even later than that on some of the private background check companies.
Sorry, I'm muted. Any other questions? All right, thank you. If you guys check out the chat, Anne has very kindly put some links in there specific to the question about housing, and then background checks as it relates to job searches as well. So please go ahead and check that out. The Legal Aid Society is working on an updated brochure. So for those of you, again, that are working in the community with people, our old brochure is now out of date, but we will have a new brochure. I think we were told within the next couple of weeks. And so that will be something that will go on our website, but we'll also have hard physical copies of that to share with you and with the community. So look for that. And it goes into detail about all of these things that we talked about today. All right. Well, thank you all for joining us. Have a good rest of your Friday. Oh, and you can request copies at outreach@lasclev.org if you'd like those brochures. Thanks so much. Bye, everyone.